past year, I've seen a number of questions come across the listserv about the ability of municipalities and their public trusts to sell or otherwise dispose of real property. As noted by Oklahoma City Municipal Councilor Kenny Jordan, one of the first inquiries must be what type of funds were used to purchase the property. If general obligation bond proceeds, as authorized by Article 10, Section 27 of the Oklahoma Constitution, were used for the purchase, any sale proceeds must be used for the same purpose or paid into the sinking fund to reimburse the taxpayers for paying off the bonds. As noted by Mr. Jordan, this particular issue was discussed at length in the case of Protest of Reed, which is a case decided by the Oklahoma Supreme Court in 1932. It can be found at 160 OK 3. In 2021, the Oklahoma Supreme Court decided the case of Emmel versus Tulsa Public Facilities Authority, a case found at 2021 OK 39. The Emmel case involved the proposed sale of park property. It is also a great primer of constitutional, statutory, and case law on the ability of municipalities and their public trusts to dispose of real property. Citing City National Bank versus Incorporated Town of Kiowa, the Supreme Court reiterated the principle that a municipal corporation holds property in two different capacities. Specifically, the court noted that there is a clear distinction between property purchased and held by municipal corporations for the use of the corporation as an entity, and that purchased and held by such corporation for the public use and benefit of its citizens. In other words, its Title II and power of disposition of property acquired for strictly corporate uses and purposes are different from its Title II and power of disposition of property acquired for and actually dedicated to the public use of its inhabitants. As to the former class, the power of the corporation to dispose of it is unquestioned. The rule is different as to the latter class. It is only when the public use has been abandoned or the property has become unsuitable or inadequate for the purpose to which it was dedicated that a power of disposition is recognized in the corporation. As noted in Dow versus Worley, under Oklahoma law, to constitute abandonment in respect to property, there must be a concurrence of the intention to abandon and an actual relinquishment of the property so that it may be appropriated by the next comer. Because abandonment rests upon the intention to relinquish the premises, it is a question of fact for the jury, with the city having the burden of establishing abandonment. It is never fun to tell elected and appointed officials that they can't do something that they would otherwise like to do. Failure to conduct these legal analyses, though, can lead to huge problems for the municipality and their officials. Educating them of these limitations in advance of proposed projects will hopefully go a long way in terms of planning for growth and development and managing expectations. OAMA, providing support to municipal attorneys through education, information, and collaboration since 1986.